A Tennessee man will spend the rest of his life behind bars for the brutal killing of a 22-year-old woman. According to prosecutors, the young woman told police she had been assaulted, and just one day later, they say that same man forced her to ingest a lethal dose of drugs, leading her to overdose and die. Authorities say it was a deliberate act, not just of violence, but control. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime.
Since I lost my daughter, my life has changed drastically. My daughter was taken from me in a horrific way, as you heard. She is my only child, and she was so young.
The mother of 22-year-old Danishka Mejia, heartbroken on the stand, speaking about the daughter she'll never see again.
I absolutely crushed by what happened to my perfect, strong daughter.
Prosecutors say Danishka was brutally killed by Latawyne Osborne just one day after she went to police and accused him of rape. Danishka told officers she had fallen asleep at Osborne's home and woke up partially undressed. Osborne denied any assault, but prosecutors say the DNA told a different story.
Mr. Osborne's DNA was present in the cervical swabs that were taken from Ms. Mejia, and semen was also detected in her underwear that was collected.
The day after she filed the report, prosecutors say Osborne and two other men, identified as Marquise Ellis and Edward Wilson, stormed into a Knoxville home where Danishka was staying. They forced her and her two friends, a man and a pregnant woman, into the basement. There, Osborne allegedly held Danishka at gunpoint, forcing her to snort a mix of fentanyl, heroin, and cocaine. Prosecutors say he filmed parts of it.
They showed Mejia being forced to snort drugs, and she can be heard telling Osborne that she can no longer get any of the drugs up her nose. There were videos of Mejia unconscious of the floor of the basement, with Young attempting to do CPR on her.
Before fleeing, Osborne and his two accomplices shot Danishka's friends, hitting one in the shoulder and the other in the hand. Both survived. Prosecutors say Osborne did not make it far. He was accidentally shot by one of his own co-conspirators during the chaos, then showed up at a local hospital. Police later found videos of the attack on Osborne's phone, including disturbing footage of him fondling and raping Danishka.
In exchange, the state has offered that we will not be seeking the death penalty.
Osborne avoided a death sentence by pleading guilty to 3 counts of attempted first-degree murder and aggravated sexual battery. His two accomplices, who prosecutors say helped plan and carry out the violent home invasion, are still awaiting trial.
Both suspects admitted to assisting in the home invasion, the aggravated kidnapping of all 3 victims in the basement.
Now, Danishka's family is left with memories and heartbreak.
My daughter was a beautiful, intelligent, energetic, and very positive girl.
And here to break down this story with me is criminal defense attorney and former prosecutor Serena Townsend. Serena, thank you so much for coming on today.
Thank you for having me.
So let's just dive right in. Such a horrible and horrific story. How common is it for a suspect to avoid the death penalty by pleading guilty in cases this severe? And what might motivate prosecutors to offer that deal?
It is really a horrific story, one that I wouldn't be surprised for a prosecution to try to, seek the death penalty for. It's common for people to take a plea rather than go to trial, simply because if they know that the death penalty is on the line or a severe penalty, it's more attractive essentially for them to avoid that and just negotiate a disposition that they could live with, literally live with, right? In this case, if he lost, he could have been put to death. So it's common for plea offers to be made, and a prosecutor thinks about a lot of things. Justice doesn't look the same for everybody, but what they have to do is consider what they're willing to essentially walk away from trial with, and of course take into consideration how going to trial would affect family and other witnesses having to relive this horrific situation.
Okay, yeah, I was just about to ask, because it seems like this would have been, if it did go to trial, a pretty open and shut case with all of the evidence, the videos, the pictures that the prosecution had. So when they choose to make deals like this one where they don't go to trial, is it usually for the family's sake? Because it seems like a jury probably would have convicted and even probably would have granted the death penalty.
It's true, and it is a decision that has to consider many, many things, including the family, including the trauma that's already been felt by the family, and their desire really to go forward and take the stand and open themselves up to that kind of testimony. And obviously, there were two other victims who did live, and they would have to testify as well. That would essentially be a very traumatic experience for them too. And of course, even though you're right, this really did seem like an open and shut case, and it probably would have been, there is still always that lingering risk that a prosecutor has to take into consideration regarding whether or not a jury is going to find somebody guilty and whether or not the person is going to get sentenced to the sentence that the prosecution wants them to get sentenced to. Even if they're found guilty, they may not get the death penalty.
Correct. Well, what challenges do prosecutors face in proving intent in a case where drugs were forcibly administered?
You know, it's hard to prove intent in general because you're asking a jury to essentially enter the mind of a person, of the perpetrator. And sometimes it's not like you have a full confession all of the time. So sometimes a jury really just has to think and look at what the person did before, during, and after. Of course, if a person is on drugs or is high and that could affect their decision making ability, a prosecution might have a difficult time convincing a jury that the individual who perpetrated the crimes was in the right mindset or had the mens rea, we like to say, to commit that crime with the requisite intent. So you're absolutely right to bring up the fact that, his mind might have been altered by the administration of drugs.
And the DNA evidence that prosecutors say that they had, how significant is DNA evidence, like the kind found in this case, in securing convictions for sexual assault? Because this all started, prosecutors say, because the victim reported that she had been sexually assaulted by the suspect, by the defendant, and they say the next day is when the death occurred.
Exactly. The DNA is extremely probative. It's very, very helpful in a case like this. Typically, when you find this type of DNA, semen or sperm cells in the location where they found it, it's pretty damning evidence. The only way kind of around that essentially is to say that it was a consensual act. The problem, of course, that the defense would have with that is that it's, from my understanding, he actually denied doing anything to her sexually originally. So it's very difficult to convince a jury that if your first statement was that you never had any sexual contact, and now at trial, now that DNA was found, you're going to change your defense to consent. A jury is typically not going to buy that.
And this was all caught on tape, according to prosecutors. They said that they had video evidence. How did the presence of video evidence, especially graphic videos filmed by the perpetrator, influence the outcome of the trial? And just a reminder, it wasn't just video evidence of the, alleged sexual assaults, it was also of the death.
Exactly. I mean, how damning is that evidence? I mean, you're essentially documenting your crimes. You mentioned this earlier. It really was an open and shut case. I mean, you have physical evidence in this video surveillance, not video surveillance, so video recordings. You have scientific proof in the DNA that was recovered, and you have eyewitness testimony from the survivors. So, I mean, it's just unbelievable amounts of evidence. I can't imagine that the prosecution would not be able to prove that beyond a reasonable doubt.
Now let's get into some of the charges. Can you explain how charges like aggravated sexual battery differ from other sexual assault charges?
Yeah, so essentially you think of criminal charges as layered. You can charge somebody with something as like a basic level assault, or then a sexual assault above and beyond that. And then aggravated assault could come into play if there's weapons, for example, or if there's repeated sexual assault, or if there's additional violence, or certain threats that are being made. So every time you add another crime essentially to the underlying crime, it kind of bumps up the severity of the crime. It changes the title of the crime, and it also changes the possible outcome with sentencing.
And what about the charge of kidnapping? What legal standards must be met to prove aggravated kidnapping, and how might that apply to this home invasion?
It's interesting when people think of kidnapping, they don't necessarily think of a scenario like this. They think of like the little kid who's walking down the street to school and is snatched by somebody who's hiding in the bushes, right? And transported to a secret location. But to be honest with you, kidnapping doesn't require all of that. Kidnapping can just be that you take somebody, without their consent to a certain location in order to prevent other people from finding them. And that location doesn't have to be, some site that's far away from where they were before. It could literally be in a secluded room in a house that they've been in before. So it really doesn't have to be what a viewer might think of traditionally as kidnapping. It's simply the person simply has to secrete another person without their consent in an attempt to hide them and commit a crime against them.
And we heard an emotional statement from the victim's mother. We also heard from other family members of the victim as well. But what role does victim testimony or family impact statements play in sentencing in cases like this?
It really adds to the context of the occasion. Obviously, a defense attorney is going to stand up there and give all sorts of mitigation about his or her client, about how, the sentence should be lower because the perpetrator had a difficult life, or because drugs impacted his ability to make cogent decisions, or all of that. Well, on the other side of the aisle, you have the prosecutor and, of course, the people most impacted by the crime itself. And that's where we get these victim impact statements. They are allowed, and they do influence, in my opinion and experience, they do oftentimes influence a judge in, the ultimate sentence. Now, here, there was a negotiated plea. And so essentially a victim impact statement in a situation like this, where there already is a decision, there's already a plea deal, and a judge has already kind of connoted that he's going to accept this negotiated plea. It's a little bit performative, I want to say, without being, I don't want to take away from it, but it probably wouldn't have influenced anything necessarily, but it is an opportunity for the family to kind of publicly address the defendant and, of course, the judge and anybody else who's watching, and really just explain literally the impact that this crime has had on the family, and explain why it was so important for this conclusion to happen in this way. It also allows a family to kind of say their piece and have their day in court, even though there's no trial where they otherwise would have been able to testify.
Right, and it probably helps with closure as well. With this horrible situation, clearly they'll never get over, what happened to their daughter. But to be able to address the man that killed her was maybe helped in some ways. We also know that Mr. Osborne was not acting alone. How does the law typically treat accomplices who help plan and carry out violent crimes but don't directly commit the murder?
Well, if you're acting in concert, then you are subject to the exact same crimes as the actor, him or herself. Now, it could be that the prosecution decides that they'd be willing to give you a better plea deal, a lower sentence, because they recognize that your role was different from the worst actor of the group. But technically, legally, you will be charged with the exact same crime. Even if you didn't pull the trigger, you will still be charged with murder if you are the lookout guy, if you helped plan it, if you helped execute it, then you are subject to the exact same crimes as the worst actor.
Now let's talk about the legal process and victims' rights. In this case, the victim reported an assault to police and was hurt the next day. What protections or measures are or even should be put in place to ensure that their safety? And what could have even been done in this case, do you think?
It's really, 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 really sad. It's really sad because we know that police have a very difficult job in trying to prevent crime and in trying to get justice after a crime does occur. And, we like to try to look into our crystal ball and say they should have known or they should have protected her more. It is kind of difficult to put it on them. But at the same time, we feel, especially victims of crimes like this, of such horrible crimes such as rape or sexual assault, that they do need to be protected. And we're always told, just report to the police and you'll be okay. Well, it didn't work out that way for her. It's just the saddest thing. She spoke out, which is the hardest thing to do as a victim of sexual assault. It's extremely difficult. Women, throughout history have not spoken out because they're afraid of retaliation like this. And I think, we could have protected her more. We meaning society, the police, the system. We as a former prosecutor, I used to tell my victims, I used to say, look, you have this order of protection against you now that you've spoken out and this court case has begun. And rightfully so, a lot of times they would say, so what? It's just a piece of paper. How is that really going to protect me? And it's just a very heinous act, and it's just such a sad situation that this poor woman, she spoke out, she thought that she would be protected by doing so, and lo and behold, he came right back and finished the job. And it's got to weigh heavily on everybody who was involved's hearts and minds.
Right. This is the worst kind of retaliation that I've personally seen. It's just such a sad story. And even during the victim impact statements, her mother said that she'll never forgive herself for not protecting her daughter more, or right after she made the complaint to police, not getting her out of town or getting her out of the state, which is not the mother's fault, but just a really, really sad situation all the way around. What are the challenges, would you say, prosecutors face when multiple victims are involved, including witnesses who were shot but survived? Because there were two other victims in this case as well.
It's interesting. A lot of times in a homicide case, it's actually a little bit easier for the prosecution to put on a case because you don't have the fear of cross-examination. Sadly, your victim has passed away. And so there's no opportunity really for the defense to cross-examine that person and to try to poke holes into their testimony, or anything like that. Like, oh, you didn't actually see the person. Maybe it was a misidentification, whatever it is. When you have multiple victims, you have to, as a prosecutor, recognize that the more people you put on the stand as a witness or a victim, the more opportunity there is for conflicting testimony. And consistency is king when it comes to a prosecution. If you put people up there and there are inconsistencies, those are opportunities for a defense attorney to really poke holes and tell a jury that that's essentially reasonable doubt and that they should not convict their client. So that's the difficulty. You have people who were traumatized, very traumatized during a case like this. I mean, they saw horrific things, they experienced horrific things, they were shot themselves. I mean, there is no worse trauma than that. And so now you're asking them essentially to take the stand and give perfect performance, not only during direct examination, but cross-examination, and to be consistent with their co-witnesses and co-victims. It's difficult to keep the story in line. So those are the difficulties that a prosecutor typically faces when you have multiple witnesses.
Right, and that's probably another reason why they decided to give Mr. Osborne a plea deal as well. And one of those victims or witnesses at the time was pregnant, very pregnant. So, I can only imagine how traumatizing that must have been. Now, we know Mr. Osborne, he had a plea deal. That's how he avoided the death penalty. He pleaded guilty and now will spend the rest of his life behind bars without the opportunity of parole. But for the other two suspects, how does the plea bargain process work when the defendant faces multiple serious charges like attempted murder and sexual battery?
Well, the first thing that I would do if I were the defense attorney is go to the prosecutor and say, look, you didn't even, end up getting the death penalty for the worst of the worst. This guy was obviously the worst of the bunch. So certainly we expect that for our clients, you're not going to seek the death penalty either. And now to take it down a notch from there, I would say, look, you gave him life without parole. Obviously, he's the worst actor. So for us, again, our clients should get a lesser penalty than that. So I think what's probably going to happen is the defense attorneys are going to try to negotiate a plea deal that's less than the deal that this individual got because their, the counterparts did not do as heinous an act as Osborne himself. The other thing to keep in mind, of course, is whether Osborne had given some assistance to the prosecution against the co-defendants. I don't know if during the plea allocution he also implicated the co-defendants. If he did, then that, of course, throws a wrench into the co-defendant's ability to get out of this, with a great deal. So I think that probably the prosecution is going to give a pretty hefty plea negotiation deal to the other side too, and then it'll be up to them to decide whether to face trial or take that deal. I would expect that they're going to try to take a deal, though.
Right. I'm definitely interested to see what that deal will be because they were present for the death of the victim, but they were not there, according to reports, when she was sexually assaulted. So I think it will be less charges just from that alone. But what recourse does a victim's family have if accomplices are still awaiting trial? Can they push for a faster resolution?
Yeah, I mean, the prosecutor, it's interesting. They don't technically represent the victim and the victim's family. They represent the state, the people of their state. But at the same time, we know very well that prosecutors absolutely take into account the feelings of the victims and their family. And so in my opinion, I think the family, especially with such a emotional, draining, traumatic experience as this just was, the victim impact statement, the sentencing, if I'm the family, I'm probably thinking like, let's try to get this over with, like the whole thing over with. Like you mentioned earlier, closure is so important. And until these other individuals get convicted and sentenced, the closure isn't fully there. So I think the family is probably going to try to push for a swift resolution.
Right. Well, this is a sad story all the way around. We definitely are keeping the victim's family in our thoughts. Serena, thank you so much for coming on.
Thank you again so much for having me.
According to WBIR, the three suspects face another trial on January 5th, 2026. For Law and Crime, I'm Kennedi Walker.